And now taking things forward for our final panel, that's on group insolvency trends and challenges. We're delighted to welcome our moderator for the session, Misha, who's partner with Shardul, Amarchand, Mangaldas Corporation. Welcome, Misha. Misha is a partner in the firm with 15 years of experience in dispute resolution and insolvency bankruptcy practice. Misha has been spearheading the insolvency and bankruptcy practice at the firm while consolidating her experience in corporate insolvency, restructuring, amongst others. She has been regularly appearing before various judicial forums, including Supreme Court of India, high courts across the country. Welcome, Misha. On that note, taking things forward, we will now be welcoming our panelists for the session. So let's welcome our panelists for the session. We welcome Mr. Rajiv Dutta, Senior Advocate, Supreme Court of India. Mr. Dutta is a Supreme Court trained mediator actively involved in the conduct of mediations at the Supreme Court Mediation Center. He is a country representative for India at International Bar Association Mediation Committee. He has been appointed as the Vice Chair of the Sports Law Committee of the International Bar Association and panel of arbitrators of Pacific International Arbitration Center, Vietnam, also an associate member of the Chartered Institute of Arbitrators, and has been elected Vice President of the Bar Association of India. Greetings, Ms. Dutta, and welcome. Moving ahead, I'd like to welcome Siddharth Srivastava, partner, Khaitan & Co. Siddharth is a partner in the Banking, Finance, Restructuring and Insolvency Practice Group in the New Delhi office. Over the past years, he has extensively worked for leading banks and financial institutions and advised clients on a various range of issues. He has advised clients in the sphere of insolvency resolution practice in various capacities too. Welcome, sir. Moving ahead, we welcome Dr. Ashok Haldia, Chairman IIPA of ICAI. Dr. Haldia's experience include industrial finance and policy enterprise, NBFC management, public sector, restructuring, industrial finance, accounting, amongst others. He has played a very important role in the past as MD and CEO of PTC India Financial Services. He's been Secretary of the Institute of Chartered Accountants of India, member of Appellate Tribunal for ICAI, ICSI, ICWAI, National Advisory Committee on Accounting Standards. He's also been with Power Finance Corporation. Welcome, sir. We welcome Pulkit Gupta, partner Ernst & Young, who has played a very important role with respect to restructuring, turnaround strategy, undertaking financial operational restructuring work. Pulkit specializes in undertaking formal insolvency appointments and independent business reviews for advising companies, lenders through multi-stakeholder corporate restructuring. He's worked on a variety of operational restructuring mandates too. So on that note, I would request our moderator for the session, Madam Misha, to take the deliberations forward. Once again, greetings to everyone. Welcome. And I hand it over to our moderator, Madam Misha, please.
Thank you, Amna. Thanks for the kind introduction. We are running slightly behind schedule. I'll deep dive into the issues because we have a very good panel here, lawyers and IPs and practitioners here. And I look forward to having some deeper understanding of the issues arising for our audience on group insolvency and how it is emerging under IBC. Mr. Dutta, if I can start with you. So, given that IBC does not have a formal group insolvency framework under the statute itself, so I want to start with your legal expertise on what are your views on this being created by court judge-made law and some framework and some ad hoc mechanism being introduced to deal with the issues which arise in group insolvency by Indian courts. Of course, we are all aware of how Videocon has come up with several tests to see where a consolidation of several insolvencies can take place. So what is, to start with, in absence of a statutory framework, what are your views on this being a judge-made law and the courts venturing into it?
First of all, good afternoon, everybody. And I, at the outset, want to thank Legal Leader for giving me this opportunity. And Misha, thank you very much for posing that question at the outset. Let me begin by saying that it's not the first time that the courts have gone into something which was developed by, in fact, the constitutional courts in our country have had in the past also been exercising their jurisdiction to develop various aspects of, law, different types of law. For example, let me also at this stage refer to the environment law. It was completely started by the constitutional courts in India by getting into the environment and trying to protect the environment, reading it into Article 21, etc., etc. We all know, we are all aware of that. And secondly, as far as the topic of the day is concerned, group insolvency, we we uh, we are now aware of the fact that there is an increased consolidation of companies in India, and the code, that is the Insolvency and Bankruptcy Code, which was enacted in 2016, it's consolidated many other legislations, and basically the theme of this act is to resolve the disputes which arise between the creditors and the debtors, and that is the reason why it was enacted. But at that point of time, they did not, and I would say whether it was a deliberate omission, they did not include into it group insolvency. And now, over the years, it has been felt, and then it is when the disputes started arising. The interesting thing that I want to mention here is that it was not the constitutional courts, as I am referring to, that is the High Court and the Supreme Court, but it was at the adjudicatory level itself. The NCLT started this process and started consolidating the disputes, and it basically started with Videocon, and then later on, of course, Supreme Court has developed this law, and in various situations which are emerging. See, law is also something which is developing on daily basis. It is not as if it is something static and we have to deal with it in a static manner. So when these disputes reach the Supreme Court, in fact, Supreme Court is the one which has been facing, as my colleagues on the panel would know, because they are all very well integrated professionals into restructuring and resolving these disputes. I am just a legal practitioner. Let me say that the Supreme Court took up these cuddles at various stages. Various sections of the code were challenged on various grounds, and the Supreme Court tried its level best to somehow save and protect this act, and knowing the difficulties which would have arisen otherwise. It led to, let me take a leap here and say that when Supreme Court was faced with a lot of problems with regard to companies which are consolidated together, and when it came a problem related to public at large, and it is at that time that the Supreme Court came down very heavily. For example, when the home buyers by various companies doing construction work were not performing, so the Supreme Court consolidated itself, the disputes, and then it took upon itself, even under Article 32, they took up these disputes, and then they have trying to resolve, because as I said earlier, the main purpose is to resolve the dispute, and not to do any other thing. The thing I want to mention at this juncture is also that, previously the lifting of the corporate veil, as we know, was very was done very sparingly, and in very very limited situations. That was the single entity law that was prevalent in our country. But subsequently, in IBC and IBC, they again structured a law which was specific to a single entity. But subsequently, the law was developed by the Supreme Court, and of course, I already mentioned it was not started by the Supreme Court, but it was felt at the adjudicatory level. Subsequently, we are all aware, Videocon, we are aware of Unitech, we are aware of many other companies where the Supreme Court has dealt with these issues, consolidated, because it was felt that these companies are interknitted companies. These companies are interdependent companies. And then the question of lifting of the veil, as I already mentioned. So this is how it started. And basically, the Supreme Court had in its mind that to maximize, so to make a maximation and specification of the creditors. So this is how it delved into, we all know the case of JP Group, that is in the case of Chitra, and many other cases. Today, due to related transactions, a group is formed, and we know it is not only that it is growing, it will continue to grow, and therefore some resolutions have to be found by also consolidating them before a certain tribunal, so that the workload and the time frame is also framed, so that these disputes are settled in one place, and people don't have to rush from one place to the other. And as I said already, that it is to resolve the disputes that the Supreme Court also has delved into it. One very important factor which I want to mention at the outset is that the problem which also is emerging for a long time after the IBC code was enacted, it has come to light that there is more emphasis, and what is happening more is liquidation. The resolutions, which is the theme of the act, is not up to the extent that it should be, and therefore we have to do something to move further in that direction. The last thing I want to mention is, and it is a very disheartening thing as a lawyer, which I have seen, and I have also felt, that one thing which the government ought to have done is, when they make these tribunals, they should make them really effective. What I find is that the tribunals have been set up, but they are not working as effectively as they should. Well, the appellate forum, I would say, yet is doing a good job. Even various adjudicatory forums, tribunals set up in the country are doing their job, but it could have been done far better. And as I have also been watching and listening to various sessions today, it is emerging that there's a lot of backlog which is getting accumulated in these tribunals. So ultimately, again, we are setting up something which we will again have to deal with in a different manner. So this is the real background. But I mean, I've already said that I'm mentioning it for the last time, at last. But also, what is really important is that we must now consolidate this law of group insolvency. The law at the moment doesn't exist. The code does not have any provisions. But in the future, if we just leave it to the courts, then of course, case-wise, every case on its own facts, they will deal with it. But the fact is that, again, every case will have to go up to Supreme Court for a decision, and we know how painful it is. So these are the opening remarks I wanted to make.
Right. Thank you, Mr. Dutta. Absolutely, I think what's important is that you are very rightly pointed out that evolvement of a group insolvency framework in absence of a statutory provisions was a necessity. And of course, the adjudicating authorities stepped into it and did their bit. But apart from the issues of delays, the question also remains that on the subject, in absence of a framework, there seems to be a certain amount of ad hocism and unpredictability in the framework. In that context, Siddharth, if I could come to you in terms of, and before I go to Dr. Haldia and Pulkit, about the industry experience and in practice, how it impacts and complicates or enables the issues around group insolvency. As a lawyer, what are your views on with the way the group insolvency has evolved, mainly on account of decisions by the adjudicating authorities tested all the way to the Supreme Court? Is that something, do you think we are going in a direction? Of course, I think Mr. Dutta has already made the point that it was a necessity, but do you think it is going in a manner where we can rely on the judicial framework to take it forward and the complexities that arise here?
Sure, thank you. Thank you, Misha, and thank you, Legal Era, for inviting us. So I sort of, in principle, agree with Mr. Dutta with respect to what he has said, whether we need the legislative framework. My take on the issue is definitely yes. And I can tell you from some bit of experience handling these cases in courts and generally on advisory, acting for the resolution professionals, acting for a lot of bidders, whether we face a lot of problems or lack of legal uncertainty when we talk about group insolvency, definitely yes. I agree that, of course, as everyone know, that Videocon judgment has laid down certain 14 criteria to determine whether one can go for group insolvency or not. But those criteria are also not cast in iron. When you go to NCLT, different NCLT would interpret those criteria differently. Whether it's a straight-jacketed formula, my answer is no. It's not a straight-jacketed formula. So therefore, and there are a lot of practical issues which come in when you go for consolidation or when you go for group insolvency. In a lot of cases, when you try to apply the judicial precedents, which is Videocon, then the court asks that whether all the companies are already admitted into insolvency, should we then therefore follow that principle? How many companies are already admitted? In how many companies Section 7 is filed so that we can have some sort of semblance? Or what happens if a company is not under insolvency at all, and does the Videocon case apply? So I'm just telling you from practical experience that these are the questions which basically come when you go to the NCLT and ask for a group insolvency or a consolidation, and there is absolutely no consensus. From my experience, I've seen there is a difference of opinion amongst the lenders also, because if you don't have common set of lenders amongst all companies, then different lenders may have different views with respect to whether a group insolvency should be commenced or not, because some lenders may be looking at it independently. Even in cases, and I can tell you from my experience, even in cases where a company is already under insolvency and one goes to the court for initiating group insolvency, because they have different set of lenders, those set of lenders would want an individual insolvency to commence and not consolidate, because of course they think that on an independent basis, the company the resolution may be more possible, and also they may lose their majority percentage if it is sort of consolidated. So those are the practical issues which I have seen in context of group insolvency. But when we talk about legislative framework, I mean, I think we should talk about legislative framework in a context. So suppose we say that a legislative framework is absolutely necessary for dealing with group insolvency, and only a Videocon judgment or certain precedents may not suffice. There are certain questions, in my view, which need to be answered and which need to be considered. And I just will quickly lay down those 5-6 bullet pointers for everyone to sort of consume and think whether those are relevant or not. Like one issue, for instance, is should all companies be already admitted under IBC to be considered for group insolvency? Or should filing of a Section 7 be a prerequisite for being eligible for group insolvency? At the same time, should there be a carve-out for some sector where a completely solvent company can also be considered for group insolvency? Because these are questions which every NCLT would ask and grapple with. So it's best that the legislation sort of addresses these questions. Also, when we talk about the criteria of group insolvency, should the legislation just follow the criteria which have been laid down in Videocon, or should we follow something like a COMI, which is Center of Main Interest, to determine what forms a part of group company? And that's something which has been sort of dealt with in jurisdictions like Germany to determine the group insolvency test. In terms of procedural aspects, should there be a common NCLT, even if the registered office of all the companies which are supposed to be under group insolvency, should one NCLT decide with respect to their fate with respect to group insolvency? How would that happen? The law needs to sort of address that. How about common RP? I mean, should there be a common resolution professional? Should there be different resolution professionals? Should there be an obligation on the resolution professionals to sort of coordinate among themselves instead of having one common? The law should also sort of address. And lastly, and not the least, of course, very, very important, is what about COC? Would there be, if there are different set of lenders in all these companies which are being considered for group insolvency, should there be a common COC, or again, like an RP situation, should there be different COC who are supposed to sort of coordinate amongst each other? So these are the basic issues which needs to be addressed by the lawmakers and the legislature before you can come up with the concept of the law relating to group insolvency. But definitely, short point is that a law relating to group insolvency is absolutely needed, and one cannot rely on different judgments to achieve the intended purpose.
Thank you, Siddharth. I think this was really insightful and laid out the ground of different controversies that arise. And there are several questions arise from the issues that you raised. But before I go on the legal issues, I want to reach out to Dr. Haldia. In your experience, what are the practical issues that the IPs are facing in running a group insolvency, which is determined and under the ad hoc mechanism of the orders of the NCLT and CLAT? So what has been your experience so far? Dr. Haldia, I'm not sure whether it's my, yes, I couldn't hear you.
Okay, now you're able to hear me?
Yes, sir.
No, first, Ms. Misha, thank you very much for inviting me amidst this distinguished panel. I'm chairman of the governing board of Indian Institute of Insolvency Professional, a fund-right regulator under the IBC 2016, and we are the largest IPA in the country, with 60%, more than 67% of IPs, and handling more than 75% in value in the CIRP cases in the country today. As a proactive body, long back, I would believe maybe 18 months, 20 months before, we set up a group on group insolvency. And that group came out comprehensively as to what are the issues and challenges and what needs to be done in the Indian context to facilitate group insolvency. We also dealt with the international experiences and what is that can be suitable for the India. To me, it is difficult to visualize a corporate without being a group entity. Now, when you can't visualize, you can't have a corporate entity without having a group entity, maybe because of ownership, maybe because of management, maybe because of the sharing of resources or backward forward economic linkages. There are. Now, if one of them goes into CIRP, how can you resolve that efficiently, efficaciously, the CIRP process? And therefore, it is evident, it is must that we need to have a group insolvency. Now, I can understand the 2016 when the IBC was evolved. It was evolved considering the environment, the ecosystem that we had in the country. Difficult to bring in such a legislation. The mounting NPAs, the problem was to challenge the NPAs first and then maybe resolve the chronic cases known as 12, referred by the RBI. But then 5 years down the road, we have achieved a lot. There could be alternative view as well. But to my view, we have achieved a lot both in terms of the number of days and also in the realization. But the time has come now for the IBC 2016 version 2. And to address all those issues we thought are complicated beginning and then maybe left to address in the times to come after creating institutional capabilities and also after learning the experience of implementation of IBC. So I believe it is high time that we have some legislation work on the group insolvencies. Now, having said that, as I said, because of commonality, it could be associate, it could be subsidiary, it could be a major controlling stake, it could be commonality of management. Now, all that goes into determining a value of a corporate debtor. Now, if you dispose of a corporate data, or if you resolve a corporate data, how can you drive a maximize value unless you pull them together? And therefore, there are two ways: substantive consolidation or the procedural. I would believe there are no other option but the consolidation of assets and liabilities, and rather than a procedural coordination and operations among the different IPs and entities and the COC members. It's difficult, it's challenging, but then I believe we know what are those challenges. I think learned speakers before me have highlighted those delays, which leads to cost and delays. Not believe, just see the current scenario. Why the executing authorities have been proactive enough, judicious enough to deal with such situation and come out with some framework. But tell me, what do you do if you have a group entities as a corporate debtor and they are listed in the same jurisdiction with the two different benches? What do you do if in the group entity, if in the group there is one is a corporate debtor, the another is also a corporate debtor, but third one, which is economically strong, is not a corporate debtor? How do you deal with that? The fourth is as the corporate arrangements are. I'm not saying corporate enter into those arrangements mischievously, but at times economic necessity or the global framework requires. So they may not have commonality of financial interest, but they have a commonality of economic interest. Now, how do you factor that? How do you factor? There are different insolvency professionals for different corporate debtors in the group. How do you ensure coordination? We had the case of Jet Airways. Now, luckily, in that case, the RPs at their level were able to coordinate with each other, and also, maybe that was first of its own kind. So it was taken up as a challenge, and maybe that coordination and cooperation among different stakeholders were established. Now, in a consortium meeting, all of you have been part of consortium representing the borrowers or the corporate debtors. In a consortium meeting, when it is difficult to arrive at a consensus amongst the lender of a one corporate debtor, how do you arrive at consensus of the lenders of the two corporate debtors, which may be similar, which may be dissimilar? Now, these are the real challenges. How do you know if a corporate debtor, for example, in ILFS has 169 entities? Now, if you have a common insolvency professional, you can't have more than an insolvency professional cannot have more than few numbers with him. How does he begin? How does he ensure the cooperation? How does he ensure the sharing of information? And every insolvency professional would be expected to maximize the value of its corporate data for the benefit of its stakeholders. So obviously they would be competing with each other. And we have seen the cases of claims and the counterclaims. Now in Adhunik, there was procedural coordination, but at what cost? In many cases, the adjudicating authorities took a view, but then possibly the cases of other corporate entities are still languishing in the courts or in the CIRP process or the liquidation proceeding. So I would believe sooner the better if we have a legislative framework. There are various ways of resolving. We had a mindset of lenders. We had a mindset of corporate the promoters. We had a mindset of the government and the regulators. That mindset in the times to come has to change. Now they have to realize that a corporate entity in the group can go into CIRP. If that happens, what needs to be done? So for example, if I am lending to a corporate and I know it has many other corporate entity and I am lender only to one entity, then in that lending agreement, at the time of lending itself, I must visualize a possibility of that entity going into CIRP or liquidation. At that stage itself, the lenders of all the group entities should sit together and then work it out as to if that happens, how are we going to coordinate and cooperate, and how are we going to share the resources? Who is going to be the lead, the lead banker on which we can depend, and then the lead banker need to generate that trust and confidence co-bankers. Co-obligors concept. Now, in that situation, all the more complications. How do you share the securities? Now, these are the things well known, and I believe, and I'm sure must have been engaging attention of RBI. We did try to persuade the authorities who matters as to what needs to be done. But then certainly they need to work, they need to sit together, work it out as to what in the best is done. Now, if they do not come together and they do not accept, for example, one of the banker as a lead banker to pursue the CIRP of all the set of lenders or the lead bankers of different consortium under the same groups as a COC. And if that doesn't happen, then what really happens? Delays. And with the delays, the erosion in the value of that, all the corporate. And who suffers? The lenders suffer. Possibly in our system, there is no accountability of delays in decision making or coordination or cooperations when because of that the value loss does take place. So therefore, I would believe the law need to be there. There need to be change of mindset, and we need to be proactive as to what needs to be done in the future, because IBC 2016, the liquidation or CIRP are going to stay. They are the two sides of the same coin. So if a success, if there are successful entrepreneurs, I would believe there will be equal number of enterprises in failure. Now, if we do not provide for that now, then possibly we are doing great justice to the economy and the society. So at this stage, thank you very much.
Thank you, Dr. Haldia. This is really insightful and brings out the core issues which we face in context of, legal issues of whether it should be procedural, or it should be a substantial consolidation. And while issues of inter se creditor rights, the conflict of, different corporates being involved and their respective stakeholders' rights and their, how that needs to be modified or accounted for in a group insolvency framework. These are some of the legal issues, but very rightly what you pointed out, that there is a huge mindset issue here as well, because we are looking at overlapping set of creditors of different companies belonging to a group, which may be, may have exposure to all or have only to individual. And there are a lot of issues which arise. And in fact, Pulkit, coming to you next, in my experience of working with you and your organization, we've gone through some very tricky issues of how to manage the inter se, mutual creditor rights. Even within a committee of creditors of one corporate debtor, there are several, pushes and pulls in different directions. And imagine in a group insolvency, it gets multifold and gets even more complicated because you have different security structure, you have different debt structure, you may not have identical set of lenders. And then COC being one of the core stakeholder which is driving the process within insolvency professional. So how have you felt like, what have been your experiences on ground of running a group insolvency, and, what are the challenges that we are facing on ground while doing this?
No, Miss Misha, if I can just add, just to emphasize the point that I made. Take the case of consortium, a normal consortium of a normal corporate. There is a lead institutions. There are maybe 10, 15, 20 lenders. One of them shares about 50, 60% of the total loan portfolio. There are a couple of others who have a stake of only 100 crores or 200 crores in a 10,000 crore project or loan portfolio.
Right.
Now, what happens in that? Now, often the lead banker, who is in authority to decide, dictates the term. Now, if he is not able to generate the confidence of a small lender as a part of consortium, because you can say you sacrifice equally or you sacrifice in an equitable manner. There are two different. If the lead banker doesn't evolve or doesn't come around on an equitable proposal and insists for an equal or proportionate sacrifice, then he loses the confidence and trust of the lenders. Now, I believe that's what I'm saying, a legislative framework which gives the guidelines, which gives the banks a background or a backup to take the call without having a fear of accountability in the future.
Absolutely. Absolutely. This is becoming a big issue, sir, not only in context of group insolvency, but even all CRPs, because somehow the way the CRPs are running and the lender's expectation seems to be more in terms of account wise. And it is unfortunate that convenient positions are being taken basis what kind of a return you can get on what basis in a particular account, rather than on the strict principles of, security, or the principles of respecting, age-long principles of priority of debts and everything. So it's becoming, and yes, there is a certain amount of mindset change needed, with the support of perhaps a legislative guidance, so that the decision makers on the ground do not feel accountable and are comfortable taking a decision which is in principle the right decision to take, rather than maximizing the return in that particular loan account. So that's certainly a very, very important issue. Pulkit, before, without any further delay, would like you to just join into the discussion.
No, thanks, Misha, and thanks Legal Era for inviting us. So, Misha, I guess the common trend, if you sort of been listening for last 15-20 minutes, I guess there is common consensus that we definitely need a legal framework. It can't be just left for a case to come up and then we decide that how the group would be resolved. But at the same time, as you sort of work through the issue, peel through the problem, it's not an easy thing to do a group insolvency. There are practical challenges. The creditors are anyways fighting in a single standalone case amongst themselves. If you sort of put 4 or 5 different COCs together, the issue will only get more complicated. It is very difficult to find an ideal group insolvency case where there are similar set of creditors with similar sort of sharing and similar set of security structure, which is an ideal scenario, which may not happen. So my view is that we definitely need a legal framework because whenever a group insolvency would come up, it would be a substantial group. It won't be normally just few small entities which can be resolved independently. So there would be high stake on value whenever they will come up. So we can't not have a legal framework. But at the same time, there would be a lot of practical challenges because of which it would be only used on an exception basis. And that is also the international practice where in US or in UK, if you see there is legal framework, but especially the substantive part of consolidation, because of all the practical challenges, would be used sparingly, and it will develop over a period of time as the experience and jurisprudence will develop. But directionally, the economy is headed, the kind of larger groups which are being created, kind of cross-border work which is happening, there is definitely a need of legal framework. And sooner we do it, better it is, because it will take time to evolve.
Absolutely. Thanks, Pulkit. This brings me to my next question, frankly, and Siddharth, if I can request you to jump in here. I think all of us have felt that there was a necessity, an ad hoc mechanism has been evolved, the courts have stepped in. There is some kind of a trial and error, but the fact of the matter is that resolving a group insolvency is, as Pulkit also put it, is a complex task. And there are a lot of complexities involved, and it's easier said and done, even from a legal perspective, and the way the case law has developed in Indian jurisprudence, it seems like that we've straight away gone, say, in Videocon, one of the most significant case, to something like a consolidated, substantive consolidation. And I'm afraid that, somewhere that I have felt, and I would like you to, just express, and rest of the panel members to tell us, what are our views on, are we leaning too far and too easily into substantive consolidation without fully realizing the complexities which are involved in a substantive consolidation? And in fact, the worldwide jurisprudence in this context is pretty, standard, that substantive consolidation has to be for an exceptional case. And otherwise, all you're looking at is, a procedural coordination kind of a mechanism, because at the end of the day, separate legal personality, issues of lifting of corporate veil, as Mr. Dutta was talking about, these are entrenched jurisprudential issues. This is not to happen on a regular basis. It happens in real exceptional circumstances. And when your whole legal jurisprudence around corporates and whose insolvency we are dealing with is based on something as fundamental as separate legal personalities, do you feel that we are going towards substantive consolidation without fully realizing, how complicated it can be, or you feel we found the right balance till now?
So that's an interesting question. I'll quickly give you my take, because I know you're running short of time. But look, first of all, we need to have some sort of a midway. It is procedural. It's a mix of procedural and substantive. Because first of all, in my view, and I agree with Pulkit, that group insolvency should not be the general rule. Group insolvency should be the exception. Let's be clear. It is absolutely, while we can sit and discuss and have our wish list, it is very difficult to sort of effectuate in principle, in practice, what we are talking about. So even if we have a legislation in place, and even if we have inculcate all what we are discussing here, and what has been already specified in various discussions, working group, committee meeting, in practice on the ground, it is very difficult to sort of achieve that. So, and therefore, we got to be slightly cautious in terms of going towards a full-fledged mechanism. This should be treated to be an exception and not a rule. And therefore, we should not completely go towards a substantive consolidation while having procedural things in place. So therefore, my answer is that group insolvency, we should take all efforts to ensure that we have the mechanism in place, whether it is talking about the substantive provisions or whether it's talking about the procedural aspects. But the initiation of the group insolvency should not be there on a regular basis. And the threshold has to be very high, and one has to sort of jot down, the regulation should come who would perhaps provide all the procedural details, niceties as to how exactly the process needs to be carried out. Everything has to be detailed to the T before we venture into it. And also taking up what Dr. Haldia said, that there are issues about consensus, and RP has to ensure cooperation is very, very difficult on the ground to ensure that. So therefore, we have to be slightly careful and not go completely overboard, and take it slow. Take it on a case-to-case basis, on exceptional cases where it is absolutely not possible to resolve the company without a group insolvency. That would be my sort of take on this.
Thank you, Siddharth, for this. I am mindful that we are a little short on time, but very quickly, Dr. Haldia, if I can come back to you, and Mr. Dutta, I'll be coming back to you again. You raised a very important issues of how committee of creditors or lenders need certain guidance from a legislative principle. It just made me think about because there are a lot of things which need to come by way of, which are an issue not strictly of law, but of a matter of code of conduct. And how and what is expected, and how conflict issues are resolved, how when a lender is wearing two hats, and it may be one institution but sitting in as a lender of two companies which are into a group insolvency. And how do you have a legislative framework which provides for, and is it even possible to have an exhaustive legislative framework which replaces an exercise of prudence and good faith, and some level of, if I can say, observance of ethical standards by the creditors on the ground? Because so in my limited experience, I felt that it's very difficult to verbalize everything in law, especially for a commercial law such as insolvency and bankruptcy, where the deliberate scheme of IBC is that we provided the skeleton, and after that we want the commercials to, evolve the blood and flesh of, everything. The moment we overprescribe, I think it kills the quality of this dynamic law. But at the same time, in absence of guidance to the lenders, we have found that we are missing the point at times by just looking at a very narrow picture on ground. So do you feel, how do you think a legislative framework can guide the lenders better, and how much of prescription should be there in such a framework?
Thank you. I think let me also for a few seconds delve in an earlier question. Substantive consolidation, that's how complex it is. We live in a complex world. When you set up a corporate, you were referring to Videocon. Corporates, I don't know how many kinds of activities and how many countries, and with the existence of assets or without existence of assets, what you can call it soft assets, intellectual property, so many things. Now, when you have a complex organization, I don't think it's difficult to evolve a complex setup for the substantive consolidation. And certainly, there have to be principles. You cannot say that because I happen to be a director of another company, I mean, both of them need to be consolidated. You need to look into the ownership pattern, the management control, effective management control, the backward and forward linkage. How can you think about, CIRP of a power sector project without consolidating it with the mining project, with mining of coal, whether that mining of coal project is under CD or as a CD or not? How can you visualize? You have to do together. Now, therefore, and I think most of the cases in the CRP, which have a large value, where the exception would become a rule rather than the rule becoming exception. So that's the one thing. That's first point. The second point, we should talk about the legislative framework. There are limits to the legislative. You rightly said the legislation should only enable and facilitate, not beyond that. It's only provide boundary, and within that it should facilitate. And in the context of the lenders, I would believe there should be code of conduct. IBBI came out with the code of conduct, which is still in the discussion, and hopefully, I'm sure code of conduct will come. But look at what impact it has taken. Many of the banks have their own internal guidelines, and internal guidelines as to how to effectively participate and contribute at the COC meeting, and that has a telling effect on the functioning of COC. That's what the law can do. Now, supposedly and hypothetically, if the law says that if there is a group, now the lenders among themselves, by any criteria, it could be the quantum of lending into each corporate, or it could be it could be any other, criteria, that they would come together to form a COC, and that COC would ensure that the small lenders who have contributed less than 10% do not get less than, often we call liquidation or whatever that we got. You can, because you remember a marginal significance of a small amount of lending by a small lender is far more than lending of thousands crores by banks like SBI. So that's how the equitable principle lies. So there could be, I'm just hypothetically saying as to what could be the guidelines, but there can be guidelines, not difficult to evolve. And what happens when you enabling framework, you empower the board to bank boards to take a decision which cannot be questioned, or they can't be held accountable tomorrow. Today there is a fear of accountability. Anything you do, they fear of accountability. So if you have a framework that enables you, if there are COC code of conduct, then possibly the banks would take a leaf out of it. And so I believe you are right. Legislation cannot be rigid or should not be rigid. It can only facilitate. What IBC 2016 does, it facilitate. Now, any matured economy should have a CIRP process only towards the fag end of the corporate life. Right, not in the beginning. You had mediation, settlement, and restructuring, and the compromise that should precede And that should be exhausted before somebody goes into CIRP. That's what a mature economy is all about. So I would believe in a mature economy, or the law can facilitate the movement of the resolution of group entities towards that. Thank you.
Right. Thank you.
Misha, can I add something?
Yes,
because
yes,
one thing which is emerging absolutely clearly as daylight is that this is not a child's play. It is something very, very complicated. And the question that also you raised was very pertinent, whether we are in a hurried manner getting into it, or whether we should step back, think aloud, and then get into it. I feel that we are very fortunate. We are rather blessed by the positive attitude that the courts have taken so far. But, in the morning, I heard Mr. Shroff, and, Vidarbha is one thing that I also felt, but it was strictly decided according to, the laws of interpretation. But, what is happening here is something different. This is not any law that you are framing. This is not a law about right or wrong. This is something which, see, for example, we have a statute in place which says we will resolve. By restructuring, we will resolve. So therefore, it is the whole economy is dependent on this. So therefore, I think the drafting will have to be very, very different and careful. And the most important thing that I learned in the morning from a session was that, in this law, we will have to adhere to only commercial wisdom. We cannot get into, the legalities and the legal wisdom of the courts and be solely dependent on it. This will have to be commercial decisions. So many times you will say, for example, I almost thought, who is going to get into Air India? It is such a losing affair. But then, there is a commercial wisdom which played its role, and somebody, went into it in depth and is trying to solve it and getting away with it. So therefore, I think we cannot simply make laws which will be to find out who is right or wrong. We'll have to apply commercial wisdom to this situation. And of course, it is a very complicated affair. See, for example, let's get on. Suppose we do come up with some legislation. Then the most important thing that I feel is the procedural coordination. I think Mr. Haldia also mentioned, how many forums are you going to have? Where all it is going to be decided? Who all are going to do it? And of course, it's a growing concern. And as Mr. Haldia also in the very beginning said, today there is nobody who's going to who's getting into big business single-handedly. They are all going to have subsidiaries, and they are all going to be interdependent. So therefore, I think your question takes a lot of precedence, whether we should still go back or we should consider single entity as a rule. But then I think the working group has done something. It's a very lengthy report that they have presented. I think, see, for example, the definition of corporate group itself is a very big, complicated affair. It's such a complicated affair that we cannot easily define that. So I think some kind of patience and some working and some thinking more into it should be done.
Right. I am just last question to Pulkit. I'm conscious that Justice Sikri is also with us, and just very quickly, because we spoke a lot on this panel about creditors' conduct and guidance on their conduct and their inter-se issues, but equally very importantly, and sometimes they're more of a target, are the promoters. So when we look at a group insolvency, and group insolvency obviously occurs in a scenario where a promoter has put in complicated structures around this. So Pulkit, as an IP, do you feel that your onus and responsibility to review and look at the suspect transactions becomes even more serious? What's your view on that?
Absolutely, Misha. That in fact is one of the big challenge when you look at group as a whole, because most of the time, in fact, in my experience, whenever you found an avoidance transaction, it is always within a group. It is always with a related party. Very rarely you will have it outside the group. And if you are sort of doing a group insolvency for 4, 5, 7, 10 entities, and then there are avoidance transaction within that group, then what would you do in terms of how would you deal with those transactions? What action would you take? So that definitely is a complicated issue, and more so in substantive consolidation, because in procedural consolidation, you still sort of treat at some level each entity on a standalone basis. So you can maybe use the current law and then sort of apply those principles. But if there is a case for substantive consolidation, then it becomes even more difficult, because you're then consolidating asset and the liability, and a lot of these transactions would actually get knocked off if you look at it on a consolidated basis. So this clearly, and this was also highlighted, I think, in the working group report, that this will be one of the challenge to implement substantive consolidation. And that is why, if I remember correctly, the recommendation was to go in a phased manner, have a framework, then have procedural consolidation, and then look for, based on the learning of step 1 and step 2, look for a substantive consolidation. And maybe that may be the right way to go forward, because we can't, like Mr. Dutta was also saying, that we can't sort of do this in one go and have everything overnight together being put in place. But at the same time, not doing anything also may not be the right way forward. It's over 3 years now since the working group report is out. And because of the complexity of the issue, nothing has been really done based on the report. But I guess the time has come. We are about to complete 6 years of IBC, where we at least have some basic principles to be put in place for group insolvency as well, and then take it from there.
Right.
Misha,
Thank you, everyone. Yes.
Misha, in a group consolidation, the avoidance that becomes far more easier, because money travels from one entity to another entity, and when it becomes group gets consolidated, it is easier to track or trace and track and identify from where the money started and from where it landed.
Right.
And
Right.
I would believe in a different way it becomes easier.
Absolutely. And even if it is not a substantive consolidation, I'm sure even when we have a procedural and coordinated, we can achieve the end by ensuring that, that the information flow between the RPs is there. So I think that will be very, very important role of RPs in a group structure. But I'm conscious of time, and thank you everyone for this interesting discussion. It's been a pleasure to host this session, and over to Legal Era for the next session. Thank you, sir.
Thank you very much, Misha. Thank you, everybody.
Thank you.